Good morning, everybody. It's 9 o'clock. We would like to get our meeting started. Ms. Reed, could you call the roll?
Yin Tu?
Yes.
Joe Rosenbaum?
Present.
Nancy Corrigan?
Nancy Corrigan, present.
Christian Lotta?
Present.
Doug Aguilera?
Present.
Carrie Ann Farrell-Hines?
Present.
Kathy Johnson?
Present.
Laura Ross?
Present.
Michael Williams?
Present.
Evangeline Ward?
Present.
And we also have Dominic Franzella and Helen Joffrey and Deanne Pierce.
Thank you for that. This meeting is being held to assist the chair and vice chairs in their leadership role and share information for those who are considering leadership role in the future. During today's meeting, Ms. Franzella, the DCA legal counsel, Ms. Jeffrey, will be discussing various topics, including the role and expectation of committee members, the chair and vice chairs, and how to conduct meeting in accordance with the Bradley-King Open Meeting Act, and CBA staff's role to support you in your positions. I would like to thank each of you for serving in the leadership capacity. Your service to the board, consumers, applicants, and licensees are extremely valuable, and as you guide your particular committee in achieving its purpose, which ultimately impacts the CBA's mission of consumer protection. So with that said, I'm sorry, did I miss something else? Nope. Okay. I would like to have each of you to Mr. Gonzalez to take over next on the agenda. Oh, sorry, I'm missing something. Okay, got it. Thank you. My first chair meeting, so thank you for staff for helping me through this. Don't hesitate to just like, yeah, and you forget something. All right, first item on the agenda is overview of role and expectation of committee members, chairs and vice chairs of CBA committees. Each of you have a valuable role in the California Board of Accountancy, whether you are a committee member or you have served as chair or vice chairs of the CBA committee. In any of those roles, it is important that you have understanding of my expectation, especially Chair Salazar expectation actually, so that the committee function effectively and accordance with the various laws that govern meetings. More importantly, it's important so that the committee can assist the CBA in meeting its consumer protection mission. Okay, so we have two types of committees: statutory committee, which includes enforcement advisory committee, qualification committee, and peer review oversight committee. And of course, we have the standing committee of CPA, which consists of committee on professional conduct, enforcement program oversight committee, and legislative committee. Of course, attendance and participation is critical, regardless of the type of committee. Attendance and participation at meeting is important to us all. The committee established dates nearly a year in advance to provide ample time for planning. When members don't attend, it can impact the committee ability to meet its quorum is not present, and also impact the committee's ability to conduct applicant interviews or investigation hearings. Similarly important is participation. The reason each of you were selected to serve as a member or in a leadership role was based on your skills and knowledge, and with the belief that you will interact and share your individual and invaluable expertise. It is okay to ask questions, share your ideas, and inquire about information. This is all part of serving and actively participating in a committee. For the chair and vice chair responsibilities, the chair of the statutory committee is responsible for ensuring that the member of the committee understands the importance of good attendance and active participation during the meeting. Any attendant participation and performance issues should be addressed first by the chair and then brought to the division chief and executive officer's attention. As the vice president of the CPA, I will also be communicating with the chairs of the statutory committee to ensure that each member who is being considered for appointment or reappointments understands the attendance and participation expectation as well. As the chair or vice chair in their absence, you are tasked with running the meeting and are ultimately responsible for ensuring that the agenda is followed and member participating in accordance with the Bagley-Keene Open Meeting Act. The CPA's legal counsel will discuss this in more detail soon. Lots of slides I saw. The chair and vice chairs are also expected to attend CPA meetings. This is beneficial to the CPA so that they can keep appraised of committee activities, but also in the chair and vice chair, but also to the vice chairs and chairs so that they are aware of the policy, discussion, and priorities of the CPA. As you are likely already aware, all CPA and committee members must complete various training courses, this is one of them. The legally required training typically must be done with a specific time frame. Staff monitor the training requirements and provide members with all the information necessary to complete the training. If members are not responsive to CPA staff regarding the completion of training, the chair or the vice chair in their absence will be asked to work with the member on gaining compliance. Do I have any questions so far before I continue? See none. CPA liaisons. I have appointed, the chair, Ms. Salazar, have appointed CPA liaison to the Qualification Committee, Enforcement Advisory Committee, and the Peer Review Oversight Committee. The liaison will be there to provide information to the committee regarding the various activities and actions that have been taken to the board level, as well as give any direction or assignment to the committees. The liaison and chairs are critical to ensuring continued communication between the committee and the board. So that concludes my remarks, but I'm happy to answer any question, and staff is here to answer any question to you as well. All right, let me grab my agenda again. All right, now we have our third item, which is presentation regarding conducting a meeting in accordance with the Bagley-Keene Open Meeting Act, and Ms. Jeffrey, so it's going to do that.
Good morning. My name is Helen Joffrey, and I am legal counsel for the Board of Accountancy. I will be presenting an overview of the Bagley-Keene Open Meeting Act, or Bagley-Keene for short. And unless it's a critical point, I'll try not to read the presentation to you. You have the printed slides. But if you have any questions about anything, please let me know. Also, when I reference the board or president, this will generally include committees or the chair as well. The law and policies of the state of California requires the business of the people to be conducted publicly. In creating the Board of Accountancy, the people of California did not yield their sovereignty to the board members and permit the members to decide what the people should or should not know. Therefore, the people shall be informed of all the activities and decisions of the board. Compliance with Bagley-Keene is critical. Each member can be found civilly liable and potentially found guilty of a misdemeanor for failure to conduct public meetings in accordance with the law. To comply, the board has three main duties. The board must, 1, give proper notice of meetings, 2, conduct business in open session unless specifically authorized by law, and 3, provide the public an opportunity to comment. What is a meeting? A meeting is a gathering of a quorum or a majority of the board to discuss or hear anything within the board's jurisdiction. With a quorum present, the discussion of the members is considered conduct on behalf of the board as a whole. This would be conducting the business of the people, and such a gathering without notice and an opportunity to comment is a violation of Bagley-Keene. Meetings also include what is known as a serial meeting. A serial meeting is one in which the members are not necessarily in the same location and perhaps do not discuss a topic at the same time, but through a series of communications with each other or through an intermediary, a quorum of consensus is created. Examples would be an attempt to guide a decision or get the opinions of the members by one member calling several members individually, one member calling another who calls another, and so on, or one non-member calling each of the members to poll a position. When the members are gathered and not discussing anything within the board's jurisdiction, this is generally not a meeting. On committees, you will see board members serving as committee members. However, there can never be a majority of the board members serving on any single committee. You may see board members observing the committee meeting. Even if their presence results in a majority of the board being gathered together, this does not create a quorum as long as the observing members do not participate. They must only observe to prevent the committee meeting from accidentally becoming an unnoticed board meeting. A quorum is required to conduct the business of the board. As mentioned, a quorum is equal to a majority or a minimum of 7. Just as members do not want to accidentally create a quorum, neither do they want to lose quorum while attempting to conduct the board's business. If the number of members at a board meeting falls below 7, the board may no longer discuss or vote. Are there any questions? Notice. One of the requirements of Bagley-Keene is to notice the public of meetings. While the members should definitely be aware of notice requirements, notice is typically managed and monitored by the board executive officer, board staff, and legal counsel. As standard practice, staff internally draft the notice and meeting agenda. The Legal Affairs Division reviews the agenda for legal compliance, and even the Office of Information Services, our IT staff, checks on dates when notice is posted to the Internet and confirms the document is ADA compliant. To provide a summary of mandates, notice of the meeting times, virtual access methods, locations, etc., as well as an agenda for every meeting must be provided for effective notice. The agenda items must also include a brief description to inform the public of the topic. For example, simply regulations is not compliant with Bagley-Keene, but discussion and possible action on amending regulations section 1 through 5 would be. Regular meetings, which is a typical board meeting, require a minimum of 10 days notice prior to the meeting on the Internet and provided to individuals as requested. Nothing may be added to the agenda within the 10 days prior to a meeting. Special meetings require a posting of the notice and agenda a minimum of 48 hours prior to a meeting, and emergency meetings require a minimum of 1 hour notice, and both meetings must also alert the media. Locations of the members during the meeting is required by law, but this requirement is currently waived through July of this year due to virtual meetings for COVID safety. Meeting locations and materials must be ADA accessible. Materials generated for the board for the meeting must be provided to the public before and at the meeting. Materials introduced at the meeting must be provided after the meeting. Any questions on notice? Open session. Just to let you know, there is a couple of summary slides, but basically move to the facilitating discussion slide. In open session, the meeting follows an orderly pattern. This permits the public to follow along and to direct the board's full attention and consideration of each item on the agenda. The agenda may be taken out of order if this option was noticed as a possibility, which is generally done. If it is not noticed this way, the items must be taken in order. A meeting may not start before the notice time, but may begin after. The president calls out which agenda item the board is starting, then the item is presented. If no action is needed, the next item may begin. If action is needed or if a member wishes to take some action, the board may discuss before a motion is made and or after a motion and a second are made. It is important that the discussion remain on topic and at minimum be on a noticed agenda item. If a motion is made without a second, discussion resumes and another motion is made. The board is asked to discuss the motion and then the public is asked for comment. Additional board discussion may occur after public comment. When discussion appears to be complete, the president calls for final discussion, final public comment, and then asks the members to vote on the motion. Voting. To vote, a member may support the motion with a yes vote, oppose the motion with a no vote, or vote abstain. An abstain vote is a vote, but essentially communicates that the member is willing to accept whatever the majority vote decides. A member must recuse themselves if there is a conflict of interest or other reason a member is, or may appear to be, unable to make an impartial vote. This includes if the member was involved in a serial meeting. The recusing member would leave the room prior to discussion. However, as stated, in order to conduct the people's business, the members present and voting must still maintain a quorum. If a recused member leaves and the board now has 6 or fewer voting members, the recused party must return. The member shall announce their reason for conflict and then remain for discussion. The member is expected to remain silent during the discussion and vote abstain. Are there any questions? Public comment. It is always a good time to ask for public comment. The board may ask for public comment before, during, or after board discussion on an item, but the public must be granted an opportunity to comment on each agenda item. In person, the president may become aware of a need for public comment when people begin to approach the microphone or raise a hand. With virtual commenters, the president should be particularly careful to ask for comment as there is no nonverbal cue. The president is permitted to set a reasonable time limit for comments. Part of every meeting is an opportunity for the public to bring up items not on the agenda. As the meeting is the conduct of the people's business, the people may ask for any topic to be considered for a future meeting or make a relevant announcement, etc. The board may not discuss the comment as, by its nature, it's not on the agenda. The board may only discuss and vote to add the item to a future agenda. However, it's not necessary to discuss or vote on placing the comment on a future agenda. This can happen internally or be an item that staff can handle with the individual. Are there any questions? Issues during the meeting. Bagley-Keene meetings are expected to be conducted in an orderly fashion for the benefit of the people. However, members of the public may make comments that seem harsh. Harsh but calm criticisms or expressions of need are an acceptable communication of the public to its members. However, personal, slanderous, or profane comments are not acceptable, and the board must maintain order. The board may ask the commenter to speak slowly and refrain from inappropriate language, request that the commenter stop the disruptive behavior, ask the person to leave, or recess the meeting until order can be restored. Even the most orderly of meetings, however, may have interruptions of the technical kind. When the meeting has an interruption, remain calm and confident, keep the public informed, and perhaps recess while the matter is addressed. If an individual appearing remotely or via telephone has a technical issue, the member should always make sure to have a staff member's contact information and alert someone as soon as possible. This is especially important when the meeting is close to a minimum quorum. Bagley-Keene permits meetings with minimal notice for specific reasons only. Special meetings would most commonly be used for this board to consider pending litigation or legislation that cannot wait for a 10 days notice. A special meeting may only be held when compliance with 10 days would impose a substantial hardship, immediate action is required to protect the public interest, and at the beginning of the meeting, before any other business is conducted, 2/3 of the members of the board, or a minimum of 10, vote to approve that a special meeting is appropriate. This board would not typically need an emergency meeting. However, these meetings are permitted when there is a situation that requires the board's urgent attention. This is generally for work stoppage or a crippling disaster that impairs the public's health or safety. As with a special meeting, the board must vote that the emergency meeting is warranted before any other business may commence. Any questions? Closed session. Closed session permits the members to discuss advice from legal counsel and litigation. Otherwise, the reasons for closed session are generally to protect the privacy of a licensee at issue or the appointment, employment, or dismissal of an executive officer. If the executive officer requests a discussion of their appointment, employment, or dismissal to be public, however, it must be held during open session at their request. To justify closed session, the reasons for closed session must be noticed with varying degrees of privacy considerations. While the discussion in closed session is confidential, the orders made in closed session are not. Ordered discipline will be posted, and action involving the executive officer must be announced in public session. And that completes Bagley-Keene training. Are there any questions? Fantastic.
You did that so well, no questions. Thank you so much for your presentation. And next on our item is number 4, the CBA staff role and responsibility, which supports CBA and committee members in meeting. Mr. Dominic Franzini.
Thank you. Good morning. So the item before you is to cover the assistant staff will provide in supporting you in your roles as committee chair or vice chair. So first, I want to make sure that you know you're not alone in this. Staff is there to provide support and assistance along the way and every step of the way. If you're kind of following along in your materials, you would have received a document highlighting the various tasks staff will perform in relation to the committee meetings, as well as a board and committee roster that notes the staff member liaisons assigned to each committee. So for our 3 statutory committees, the Qualifications Committee, the Enforcement Advisory Committee, and the Peer Review Committee, we have assigned a liaison and program management. We'll draft the agenda for each meeting and provide it for the chair for review. For the board's advisory committees, the Legislative Committee, the CPC, and the EPOC, staff will work with President Salazar in drafting these agendas. And once approved internally, as Ms. Joffrey had noted, each agenda is reviewed and approved by the department's legal counsel to ensure compliance with the Bagley-Keene Open Meeting Act. And as noted by legal counsel, the agenda will be posted prior to the 10-day notice period on the board's website. But as chairs and vice chairs, you don't need to worry about this. Staff is something the staff monitors, has calendared, and will ensure that we meet all Bagley-Keene notice requirements. Prior to each committee meeting, the assigned staff liaison will schedule a conference call with the chairperson to go over the upcoming agenda, provide a brief summary of the agenda items, and answer any questions you might have. If there's anything on the agenda that might be challenging or controversial, staff will also be sure to share that as well. Staff liaison will provide talking points to assist the chair in facilitating the committee meeting and will provide a summary of the meeting to the so that you can provide that report to the board at a later date. I know the idea of facilitating meetings might seem a bit intimidating or overwhelming sometimes, but we work really hard to make the job as easy as possible. You have tip sheets, and staff are available right next to you during the meeting in order to try to help make and facilitate the meeting as expeditiously and as seamlessly as possible. It is our goal to make your time in the leadership position stress-free and enjoyable, actually, not to be worried about kind of running the meeting itself. If there's anything additional we can do to assist, all you have to do is ask. As it relates to travel and meeting logistics, when we start resuming more of that travel, especially in Southern California, staff will secure meeting locations. We've been meeting, obviously, either virtually or at the board's office. If and when we start traveling again, we will secure those locations in Southern California. But regardless of those meeting locations, staff are available to assist members with any travel arrangements. Staff are also available to assist with travel expense reimbursements following each committee meeting. But the last item I'd like to touch on is contact from consumers or licensees outside of the meeting. While this doesn't happen very often, should it occur, please refer them to me if I'm not here, to Ms. Pierce, and they can call my cell phone, the board office, at any time. Either is fine. It is likely if a consumer or licensee reaches out to you directly, they have already been in contact with board staff and are looking for your support with the issue they are dealing with. This could be an investigation under review by the Enforcement Division, or a deficiency with their license application, or a renewal issue. But if you are contacted by any applicant regarding the status of their application for the exam of licensure, again, please direct them to our office. You can direct them to me specifically, or in my absence, Ms. Pierce. I know there are times where processing applications may impact their job, offer a promotion, so we want to make sure we can assist them when we can. Engaging in conversation or other form of communication outside of the meeting could create a conflict of interest for you, resulting in you potentially having to recuse yourself if a matter comes before the board or one of its committees. And despite the fact that we use the board's address and phone number on our public rosters, we all know with Google or with any other kind of searching around in today's technology, it's quite easy to find individuals and get your direct contact information through social media, business website, or just any type of search. And if you're contacted by phone, it is best not to let the conversation go too far. Once you realize that you're speaking with a consumer or a licensee and it's related to board business, the committee you're on, even if it's not the committee you're on, I'd recommend you politely interrupt to kind of stop that conversation a little bit and give them my contact information, or let them know you will reach out to me or this office and we will be in contact with them. If the contact is by email, once you've kind of started understanding what that email is about, we recommend that you stop reading the email to minimize that conflict that may arise, and forward it to our office. Again, you can forward it directly to my email address, and we will coordinate to make sure we get the response out. If you receive a letter by mail, again, treating it a little bit like the email, once you've digested that this is a consumer contact, it's about board business, we would suggest you cease reading the letter and forward it to the board forward to the board's office, and we will process it and handle it accordingly. Really, under no circumstances should chairs and vice chairs be responding to these emails or letters on their own, simply not because we don't think you're able to do so, but to minimize that conflict and that issue. So if it comes before your committee or it comes before the board, that you're in a position to actively participate, but also that we want to make sure that it's the message from the board as opposed to a singular member. And if you are invited to join a call or a meeting by any outside organization or stakeholder, or if you are asked to speak on behalf of the board in any manner, it must be approved in advance. Please always clear these with situations through, especially if it's for the QC or the Enforcement Advisory Committee or Peer Review Oversight Committee, direct those to the program chief or to myself directly. That way we can work with the leadership to determine whether or not this is an item that we want to present on or provide a presentation on, and what that message may be, and so that it's the board's message, which is ultimately what we're trying to convey there. So with that, I'll turn it back over to Vice President Tu, and I'll be happy to answer members' questions along the way.
Thank you for that presentation. Does anybody have a question? Because I do have one question for clarification. Now, if we can email or letter and it's CC to staff as well as everybody on the board, you still want us to forward that to you directly instead?
Yeah, I would always, even if you see a CC or you recognize that it's most likely been copied to other members and we may have it, I would always advise sending it to us just to make sure we do have it. So.
Any other comments or question? Yes, go ahead.
I just want to say during my time as chair or vice chair that I've had great interaction with the staff. Preparing, meeting, it makes it fairly seamless, especially when I'm trying to figure out what I'm supposed to say and et cetera. So kudos to them.
I would concur with that comment. It's been a joy working with you all as staff. Head nodding, so we have a lot of experience, chair and vice chairs here as well. Any other comment? If not, our meeting is adjourned. Thanks.